Without further ado, I'll kick off then with my case, which is the National Council of the Society for the Prevention of Cruelty to Animals, which I'll refer to as the NSPCA, versus the Minister of Environmental Affairs and others. And the reference is 2021 SA 249 GP. This case relates to the process by which South Africa sets annual export quotas for trade in lion bone, bone pieces, bone products, claws, skeletons, skulls, and the like, which the court refers to as lion items, for commercial purposes which are derived from captive breeding operations. The facts are briefly as follows. The quotas for the exportation of lion bone were determined at 800 lion skeletons in June 2017 and 1,500 skeletons in June 2018. These decisions were taken on review to the North Gauteng High Court, where Judge Jody Collipin presided. The court pointed out that it is estimated that there is an excess of 9,000 lions in South Africa, with some 6,000 of them in captivity and the remaining 3,000 or so in the wild. In the Biodiversity Management Plan, or the Plan for Lion, published by the Minister in December 2015 in terms of the National Environmental Management Biodiversity Act, or NEMBA, it is recorded that, and I quote, lions have been an iconic species for humans for thousands of years, appearing in cultures across Europe, Asia, and Africa. The lion is a powerful and omnipresent symbol, and its disappearance would represent a great loss for the traditional culture of Africa. The judgment quoted that. The same plan in dealing with captive lions offers the observation that captive lions are bred exclusively to generate money. And it does appear that while on the one hand a distinction is made between wild and captive lion populations, the plan, says the court, also seeks to deal with what it describes as a well-managed captive lion population that has minimal negative conservation impacts. And in the detail setting out the objectives and actions that the plan seeks to achieve, it commits itself to develop national standards for the captive keeping and breeding of lion. The court referred to the broader controversy about whether breeding lions in captivity contributes to the conservation of the species, but commented that this case is not about that debate, it's about the lawfulness of the quota decisions. The trade in lion bone at international level is governed by CITES, the Convention on International Trade in Endangered Species of Wild Fauna and Flora, of which South Africa is a party. The CITES website describes its aim as being to ensure that international trade in specimens of wild animals and plants does not threaten their survival. Until June 16, there was no legal restriction on the quantity of lion bone that could be exported, but African lion is on Appendix 2, which includes all species which, although not threatened with extinction, may become so unless trade in them is subject to strict regulation to prevent utilization incompatible with their survival. Appendix 1 would include all species threatened with extinction, such as rhino, and trade in them would be subject to particularly strict regulation and authorized only in exceptional circumstances. In 2017, at the conference of the parties to CITES in Johannesburg, there was added an annotation to African lion on Appendix 2 requiring that if South Africa wished to trade in lion bone sourced from lions in captivity, it was required to establish annual export quotas for lion bone and communicate them to the CITES Secretariat, which it did. NEMBA creates a framework for quotas and establishes a scientific authority which must monitor legal and illegal trade and advise the minister. It must conduct scientific and professional review and have public participation. The authority must then make a NDF, a non-detrimental finding, before the minister can determine a quota. At the public meeting, the SPCA alleged that there were endless records of lions in captivity being underfed, malnourished, neglected, bred repeatedly, and confined in overcrowded and cruel manners. The minister and the department said the minister was only required to consider scientific information and did not have the responsibility in law for regulating and enforcing welfare standards for wild animals. The welfare of lions bred in captivity was not a factor regarded as relevant in determining the annual CITES quota. The SPCA had sufficient powers under the Animals Protection Act to look after that. The NDF concluded, that's a detrimental finding that lion skeletons from captive breeding operations was not detrimental to the survival of lion in the wild, and the quota was set. So the court in this case went back to the environmental right in section 24 of the Constitution and cited the Constitutional Court in the NSPCA versus the Minister of Justice and Constitutional Development. That's a 2017 Constitutional Court that I'm going to quote from substantially. Colopin J, in our case, regarded the following dictum, which I'm going to quote, as unambiguous and compelling, recognizing that animal cruelty was prohibited both because of the intrinsic values we place on animals and to prevent the degeneration of the moral status of humans. Now, this is a long quote, so as a visual cue, I'm going to hold up my ruler because I'm quoting the Constitutional Court, which our court quoted. And I quote, more recently, Cameron J., minority judgment in the Openshaw case, recognized that animals are worthy of protection not only because of the reflection this has on human values, but because animals are sentient beings that are capable of suffering and of experiencing pain. The High Court in the Predator Breeders Association case championed this view. A unanimous full bench found that canned hunting of lions is abhorrent and repulsive due to the animal's suffering. On appeal, the Supreme Court of Appeal did not dispute this finding. The Supreme Court of Appeal in the Lem Tong Tai case explained in the context of rhino poaching that constitutional values dictate a more caring attitude towards fellow humans, animals, and the environment in general. The court concluded further that this obligation was especially pertinent because of our history. Therefore, the rationale behind protecting animal welfare has shifted from merely safeguarding the moral status of humans to placing intrinsic value on animals as individuals. Lastly, Lem Tong Tai is also notable because it relates animal welfare to questions of biodiversity. Animal welfare is connected with the constitutional right to have environment protected through legislative and other means. This integrative approach correctly links the suffering of individual animals to conservation and illustrates the extent to which showing respect and concern for individual animals reinforces broader environmental protection efforts. Animal welfare and animal conservation together reflect two intertwined values. End of the Constitutional Court quote by our court. Our court found that animal welfare was relevant to the quota decisions and they were set aside. The court also held that it would be a contradiction if we are to suggest that different standards and consideration should apply to our treatment of lions depending on whether they are in the wild or in captivity. So what can we glean from this case from the perspective of Earth Systems law, taking up the suggestions of Prof. Louis Kutzer in his keynote address? And I quote him, "The main challenge is, if environmental law already has systemic qualities, we just need environmental lawyers to recognize and revise the law to govern in line with Earth Systems thinking." The Earth Systems construct possibly is already largely in place, and one simply has to become aware of it in the articulation of the constitutional principles. Here are half a dozen of the principles of Earth Systems law that Louis mentioned. Consider the impact of human interactions and how it arises. Adopt an integrative approach. Tackle not only the externalities, but the structural processes. Introduce the context of complexity into scientific debates and practices. Recognize that humans are part of a vulnerable Earth system. Adopt a paradigm that is system-oriented and sensitive to Earth system vulnerability. This is not a synopsis of Louis' talk, which was far more extensive. But if we then take that quote that I read to you and intersperse a few words into it, we can see how close to Earth Systems law paradigm this can become. So, for example, the quote from the Lem Tong Tai case, "Constitutional values dictate a more caring attitude towards fellow humans, animals, and the environment in general," add the words. And this includes a consideration of the systemic impacts on the environment arising from human behavior. Taking the essay Predator Breeders quote, "The rationale behind protecting animal welfare has shifted from merely safeguarding the moral status of humans to placing intrinsic value on animals and individuals," add the words, as well as the environment in which they live. The quote from SA Predator Breeders: "Animal welfare is connected with the constitutional right to have the environment protected through legislative and other means." I'm going to start interspersing a few words here. Sorry if it's a bit confusing, but I can't resist. Animal welfare, in other words, and the protection of the environment in which animals live, is connected with the constitutional right to have the environment protected through legislative and other means. This integrative, add the word earth systems, this integrative approach correctly links the suffering of animals, individual animals, to conservation, and illustrates the extent to which showing respect and concern for individual animals, add the words, and the environment in which they live, reinforces broader environmental protection efforts. Lastly, animal welfare, animal conservation, add the words, and environmental conservation together reflect intertwined values. So this case shows a willingness to depart from the traditional linear scientific approach that addresses discrete, unrelated environmental problems. I would venture to suggest that the courts may take judicial notice of the fact that we cannot take Holocene stability for granted. Thanks, that's my effort.